As a Canadian, I find this judgment to be shocking. The courts upholding First Amendment rights even in the time of an emergency?
Oh, won't somebody please think of the children?
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, and this is an update on a vlog I did a while back about a high school student who was apparently threatened with jail unless she deleted an Instagram post. If it sounds absurd,
it's because it is.
The original story is of one Amiyah Cohoon, who is a high school student in Wisconsin, and last year she fell ill with what was suspected to be the Rona, or as we were calling it at the time, the My Coronavirus. She went to the hospital with an upper respiratory problem. She was told that she probably had COVID, even though she tested negative for it because she might have missed the window of opportunity to be positively diagnosed with COVID. She thought she had COVID. She posted 2 posts to Twitter, one saying she had fallen ill and another of her with an oxygen mask on saying that she was going to beat COVID-19. Apparently, the authorities did not take too kindly to those Instagram posts for whatever the reason, and a sheriff showed up at her house on one evening and told her to remove the posts from Instagram, failing which people were going to go to jail. We will get more into the fact pattern as we dissect the judgment, but long story short, Amiyah Cohoon then subsequently sued for First Amendment violations, and lo and behold, she succeeded in her claim. United States District Court, Eastern District of Wisconsin, Amiyah Cohoon plaintiff versus Joseph R. Conrath, Cameron Klump defendants. Order granting plaintiff declaratory judgment. The SARS-CoV-2 virus and COVID-19 have had a tremendous impact on American society, but as this case makes clear, that impact has its limits and, more specifically, does not extend to overriding the protections of the First Amendment. On April 16, 2020, teenage plaintiff Amiyah Cohoon, Amiyah or plaintiff, by and through her parents, Rick and Angela Cohoon, Mr. Cohoon and Mrs. Cohoon, filed a complaint alleging defendants Sheriff Joseph Conrath and Patrol Sergeant Cameron Klump violated Amiyah's First and 14th Amendment rights when Sergeant Klump, at Sheriff Conrath's direction, demanded that Amiyah remove a social media post detailing her repeated hospitalizations with COVID-like symptoms. As a remedy, Amiyah seeks both declaratory and injunctive relief, including an order barring defendants from threatening or taking coercive action against her if she posts on social media in the future about her scare with COVID-19. On April 24, 2020, defendants moved for summary judgment, and on May 15, 2020, Amiyah filed her own summary judgment motion. Now, the procedural posture of this decision is kind of interesting. It seems that both parties moved for summary judgment, which basically means that both parties agreed on a specific set of facts such that there was no need to have a trial on the facts. All the facts were there, all of the facts were admitted to, and all that they needed was a judge to come to a determination based on those agreed upon facts. And that is made clear in the first line of the second paragraph of this judgment. The parties agree that the facts are not disputed. Indeed, the entirety of Sergeant Klump's encounter with Amiyah and her parents is captured in a dashcam video. That video, along with other record evidence, establishes that defendants violated Amiyah's free speech rights by demanding that she take down her social media posts or face criminal citation or arrest. The parties admit that the defendants, the sergeant and sheriff, threatened somebody with citation or arrest unless Amiyah removed her social media post. Steve Lito did a breakdown of this very judgment today, and he went on, and rightfully so, about the fact that the defendants apparently publicly stated that no one was threatened with arrest, and yet in the judgment they all seem to agree that yes, indeed, people were threatened with arrest unless Amiyah took down the social media post.
Again, I am still baffled. This is a quote from NBC15.com. An attorney for the sheriff and the Marquette County Sheriff's Department said no one was threatened with arrest. The complaint says the parties agree, the facts are not disputed, and the police basically demanded she take down her social media posts or face criminal citation or arrest.
Why would the police make one statement publicly and then make an admission to the opposite effect in the judgment is up for anyone's guess. Were they trying to spin things publicly? Were they hoping that this would never get to a judgment? Who knows? Bottom line, it would seem that the sergeant and sheriff made public statements through their attorney that were factually contradicted by their admissions in the lawsuit. They did, in fact, admit to having threatened someone with arrest unless a 16-year-old girl took down her Instagram social media posts about her battle with COVID-like symptoms. That is one heck of an admission to make, and after that, it is all downhill for the defendants. Now, the judge grants the motion for summary judgment and grants the motion for declaratory relief by the plaintiff. The judge does not grant the injunctive relief for obvious reasons. The request for injunction was overly broad on the one hand and also sort of unenforceable in that the plaintiff was asking for an injunction enjoining the defendants not to threaten her in the future, and we can obviously see why that would be a very difficult conclusion to implement, but the judge grants the motion for declaratory judgment and says, yes, your First Amendment rights were obviously violated. There is no dispute that Amiyah's injuries are the direct result of, and thus, quote, fairly traceable, end quote, to defendants' conduct. She took down her social media posts only after Sergeant Clump's visit to her home, and because the chilling effect on her protected speech is her injury, and that chilling effect persists to this day, it is likely to be redressed by a favorable judicial decision. Thus, plaintiff has met the standing requirements necessary to trigger this court's authority to issue declaratory relief. The court then goes over the three elements of a First Amendment retaliation claim, which are as follows. The record establishes all three elements of a First Amendment retaliation claim. Quote, as a general matter, the First Amendment prohibits government officials from subjecting an individual to retaliatory actions, including criminal prosecutions for speaking out, end quote. Quote, to prevail on a First Amendment retaliation claim, a plaintiff must establish three elements, end quote. First, she must show she engaged in protected First Amendment activity, end quote. Quote, second, she must show an adverse action was taken against her, end quote. Quote, she must show her protected conduct was at least a motivating factor of the adverse action, end quote. Here, plaintiff has satisfied all three elements. And I must say that as a Canadian, I find this vigorous protection of First Amendment rights to be very, very scary. I mean, there's a lot of people online saying very mean things, and if the courts do not prohibit them from saying those things,
people might get insulted.
People might make social media posts about what they perceive to be their own battle with COVID-19, and then what's going to happen? Society is going to fall apart. The court goes on to explain how social media is effectively First Amendment rights by definition. Even if short and often grammatically scurrilous, social media posts do not fall outside the ambit of the First Amendment. To the contrary, they are exactly what the First Amendment seeks to protect. And just how do the defendants argue that the social media post was not protected by the First Amendment? Wait until you hear this. But defendants disagree. In their view, Amiyah forfeited her constitutional protection when she published a post that caused concern in the community and led to an influx of phone calls to the Westfield School District and Marquette County Health Department. According to Sheriff Conrath, this was akin to, quote, screaming fire in a crowded movie theater, end quote. Even setting aside that the popular movie theater analogy actually referred to, quote, falsely shouting fire in a theater and causing panic, end quote, the Supreme Court, quote, has rejected as startling and dangerous a free-floating test for First Amendment coverage based on an ad hoc balancing of relative social costs and benefits, end quote. Bottom line, it was obviously protected speech, and invoking the greater good is not a sufficient justification to violate that First Amendment right. Then we get into the retaliatory actions taken by the defendants. Defendants took adverse action against plaintiff. Quote, the standard for determining whether an action is sufficiently adverse to constitute retaliation is well established. It must be likely to deter a person of ordinary firmness from continuing to engage in protected activity, end quote. And based on the agreed upon facts in this case, the court obviously comes to the conclusion that this was obviously retaliatory conduct by the defendants. First, the record makes clear that Sergeant Clump's intention throughout his 30-minute visit was to get Amiyah to remove her social media posts through the use of threats against her and perhaps her parents. That he expressed this intent only during his discussion with Amiyah's father after Amiyah had retreated into the house to comply with the police officer's demand does not mean that she was not the realistic subject of threatened police action. Indeed, it appears that Amiyah made the logical hop necessary to infer the sergeant had threatened her arrest because, in her sworn declaration, she recalled, quote, after Sergeant Clump left, I was afraid that he would find my first post and come back for that one, so I deleted that post too, end quote. Moreover, she stated, quote, I would also like to post further about my scare with COVID-19 on social media and to repost the posts I removed, but I am afraid that another officer will come to my home and cite or arrest my parents or me, end quote. So not only was Sergeant Clump's threat of arrest likely to deter a person of ordinary firmness from engaging in protected conduct, in this case it did just that. The defendants then tried to invoke probable cause or qualified immunity to escape liability, but to no avail. Defendants' probable cause argument dramatically understates the probable cause analysis for disorderly conduct. If accepted, defendants' position would largely gut the First Amendment's protections for free speech, allowing police officers a free hand to wrongfully arrest anyone engaging in protected speech so long as the offending officer could point to a possible disturbance or perceived anxiety among those who opposed the speech. And with respect to qualified immunity, the court concludes as follows. Defendants fare no better with their invocation of qualified immunity. It is well established that qualified immunity does not apply to requests for declaratory relief. As a result, defendants cannot use qualified immunity as a defense to Amiyah's declaratory judgment claim. Since money damages are not an issue, the court will not reach the question of whether qualified immunity would have applied in that instance. The court then goes on to explain why it is not granting the injunctive relief, and it's relatively obvious why, but let's just go through that very quickly. Plaintiff's motion for injunctive relief seeks to, quote, enjoin defendants from citing her or her parents for disorderly conduct, arresting them, jailing them, or threatening any of the above for future posts on social media about her scare with COVID-19, end quote. The court denies this motion. Normally, injunctions should be narrowly drawn to prohibit only the violation established in litigation or conduct reasonably related. Plaintiff's motion requests something more akin to carte blanche. Even injunctions ordering a party to obey a specific law are often struck down for overbreadth. This is pretty self-explanatory. Basically, the plaintiff was seeking an injunctive order enjoining the defendants from threatening her in the future, basically ordering the defendants to not break the law in the future. The judge concludes that it's overly broad and therefore unenforceable and denies the injunction, but grants the declaratory relief, which is basically all the plaintiff wants in the first place. And the concluding paragraphs of this judgment are actually just beautiful. Conclusion: the First Amendment is not a game setting for the government to toggle off and on. It applies in times of tranquility and times of strife. While defendants in this case may have believed their actions served the greater good, that belief cannot insulate them. Demanding a 16-year-old remove protected speech from her Instagram account is a First Amendment violation. Declaratory judgment is granted. Accordingly, it is hereby ordered that plaintiff's motion for summary judgment under Federal Rules of Civil Procedure 56 ECF number 33 is granted. First Amendment protections are not a game setting that the government can toggle on and off. You've got to love that analogy. It is simple and it is impactful. And First Amendment protections do not just apply in times of tranquility, they also apply in times of strife, and possibly more so in times of strife. It is not because we might be in times of strife or times of crisis that First Amendment protections go out the window for the greater good. This judge gets it.
This judge got it.
So that is one heck of an ending to a lawsuit that should never have been filed in the first place, because the police should never have done what they did in the first place, but at the very least we have something of a happy ending to this lawsuit. And if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of these support links are in the pinned comment. Robert Barnes and I do weekly streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, where supporters get a lot of exclusive content, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, so you can catch it there, but more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Oh yeah! Oh yeah! Oh yeah, you sweet little bastard.